Welcome back. So let's have more of that discussion around the Constitutional Court having ruled today that Section 26.1 of the Registration of Births and Deaths Act is unconstitutional, finding that it discriminates on the basis of gender. And so what the ruling then does now is essentially gives Parliament 2 years to amend the legislation and essentially allow for men to take their wives' surname when they do, of course, unite. We get your calls on this one, 010-594-6010. You can send us a WhatsApp on 072-110-5584. We're joined by legal expert Benedict Piri. We're joined also by cultural expert Professor Mosaqulu, and from the University of the Western Cape's Gender Equality Units, Dr. Figile Vilagazi Alberts. A good evening to you all, and thank you so much for joining us. I do want to start with the legal side of it, Benedict, if you'll allow us. The argument that has been put forward by the two couples, certainly what this ruling does and the precedent that it sets from a legal point of view, any sort of technical red flags that you might see moving forward?
Good evening, Naledi, and good evening to the viewers. I think it's such a good ruling, Naledi. I mean, even when it came through the Free State High Court, it was a good ruling because what we heard from the Constitutional Court today was that there was no legitimate government purpose for that discrimination with respect to the registration of the surname, and also that it actually anchored itself in a colonial practice, which had then obviously furthered this idea of patriarchy in society. So it was necessary that a court ruling undoes not only the colonial legacy, but the patriarchal roots which had found its way into our legislation. I don't see any red flags. In fact, the court was very careful to even extend the wording to people that are in civil unions and not necessarily those that are in a heterosexual relationship strictly, insofar as it fashioned the reading into that Section 26. So I think it's quite a bold and decisive ruling from the Constitutional Court that's with keeping with the times and the evolvement of, tearing down these colonial and patriarchal vestiges. I think it will be good for the country going forward, and not so much that there would be any red flags.
Okay, well, this is going to be something to watch. We've seen some cultural voices starting to come up that maybe not so much in support. Perhaps, Prof. Kulu, you can give us your perspective as a cultural expert. The ruling, the husband can now take the woman's surname. Is this a step in the right direction or not, in your view?
Well, thank you very much. And I fully agree with Dr. Piri on the issue of the ruling by the Constitutional Court, because you must remember that the Constitutional Court looks at the Constitution and the provisions of equality, in fact, even cultural equality, which is a very important concept now, has been dealt with by this ruling. There has been a tendency when it came to issues of coloniality that the things that were introduced by the colonialists, we over time tend to think that they are part of our culture. It was not always like that. For example, the issue of lobola among many Africans, starting with KwaZulu, in the 1850s, to make it 10+1 cows, was introduced by the colonial system. It was never part of our traditions. But because it remained unchecked, it has now become known as being part of our traditions. The cultural voices that are coming up because I think that many think that the ruling says husbands now must take the surnames of their wives. Now, let me explain this thing again. In any, for example, Zulu homestead, there are two surnames in operation there all the time. If there's one husband and there's one wife. The first surname is the major one, is the surname of the husband. But the wife, when she arrives in that new kind of family to go and marry there, she comes with her surname. So if her surname is Nene, she will always be known as Ma Nene. The Nene aspect, her original surname, is never dropped. So this is not completely new. It balances even more and makes the decolonization project to be now coming to fruition. What will happen is that we will soon know the difference between those cultural practices that were introduced by the colonialists and those cultural practices that are pre-colonial. I think this ruling gives freedom in a pre-colonial sense.
Very interesting perspectives. Dr. Vilakazi Alberts, your reaction to the ruling, are you in support? What do you think this will do? And now the debate on the table around many homes tonight is masculinity, what this starts to do to how we actually view masculinity in the traditional sense. What's your view?
Good evening, Naledi, and to viewers at home. I concur with the speakers that this is a landmark ruling, I think, in the country, particularly at the time when we know Home Affairs is busy actually trying. I think there's a marriage amendment bill that is in circulation as we speak, Naledi, that is trying to do exactly what the court has done now. So this ruling basically shows us that we have never stopped doing what Professor Tolu is explaining, particularly in African society. There's always been the usage of multiple surnames, that of the matriarchal part of the side of the family and the patriarchal side of the family. So it's a practice that has been happening, but what has happened is that with colonization and apartheid and slavery, I want to also add, our system was disrupted, right? The common law, African common law, has always embraced the masculinities and femininities of, in the arrangements of love, and marriages. So that is something that is, I think, a reminder and a point of return. I might imagine that our courts have been able to take us back to that place. And in terms of masculinities, I really want to say patriarchy also is a system that was introduced to us as African people. And if you remember, Naledi and viewers at home, African societies really always appreciated matriarchy and the role of matriarchs in our society. I mean, you don't have to look further. In South Africa, we've got the Mojajis. There's never been a problem within the Balobedu people to use the surname of the mother, because a mother is an institution in African society that is highly respected, highly revered, which is why when you enter into a union of marriage, you are received beautifully as Umandaba, Oshatela Gwazondi, Umandaba, that is being, connected through marriage into the union of another surname. I think the law has really disrupted that, and that for me, this remedy corrects that, and I'm hoping that Parliament in the next 2 years will really just realign ourselves in terms of the law, but also in terms of who we are as a people. And it is a beautiful dismantling of patriarchy, I must say, which is a system that was forced down our throat to teach us that men are dominant more than women, is something that really predominantly has never happened much in African societies and in our practice, and even today, as we know. Although there's learned behavior that is patriarchal, which has necessitated then that we see some elements of dominance that come from one gender to other genders, and gender not really being male and female. We know that genders in African society are also appreciated to be multipled. We recognize the fact that there are third genders, there are multiple genders, which are really connected to our spiritualities, and the reading into this remedy, as Mr. Piri indicates, appreciates that as well, to say that we also do have same-sex relationships in our civil union arrangement. So this is really beautifully bringing all of it back to where it was before in a beautiful way, including even religious marriages. We know there are also some decisions that were made recently regarding Islamic marriages, for instance, where women never really enjoyed certain benefits. But with this remedy, everyone in South Africa, regardless of gender, race, class, nationality, and so on, would be able to enjoy these benefits. So it's a beautiful, really, return from patriarchy.
Okay, very fascinating. Let's get some calls now, 01059461010. Peter's calling in from Foshville. Peter, good evening.
Good evening, ma'am.
Good evening. Thanks for calling, Peter. Talk to us. Your view.
Yes, my view is that the man is having the seed. You cannot trace the seed back to the lineage. If you now all of a sudden you give the surname of the mother. Like for instance, I'm from the Mtembu clan. Now all of a sudden I'll be Kumalo clan. And then my children will also be Kumalo clan. And then now you've lost the lineage. And if you look at it biblically, you check the biblical genealogy, like for instance of Jesus Christ, there is nowhere where the female is taking, the male is taking the female surname, because the seed is from the man. So the DNA is very important that it is registered accordingly. Immediately now you swap the DNA now, you say now is the DNA of the other clan or from the female side.
Okay.
That will be wrong, yes.
Okay. Peter in Foshville saying that we've got some issues here in terms of what we do then with the lineage of the children. Peter, thank you so much for calling. Sbusiso is in Katlehong. Sbusiso, good evening.
Skumbuzo.
Oh, it's Skumbuzo. Skumbuzo, good evening. Apologies. Thanks for calling.
Yes.
Go ahead, sir.
Mina ngiyiphikisa impela nje lento lena ayifanelanga kahle kahle ivunyelwe futhi afanelanga uhulumeni aphasise lo mthetho ngoba iqeda ubuthina uthi singobani.
Okay.
Iyasilulaza kahle kahle kusho ukuthi sigcina singasazazi manje ukuthi singobani. Ziningabi izinto ongabe uhulumeni usenzela zona ofuneka senzele zona kodwa kunokuthi asenzele zona uqeda isizwe.
Okay. Babus Kumbuzo, thank you so much for calling. Babus Kumbuzo there in Katlehong saying that this is a step backwards. This is, in fact, going to be really bad for how people see themselves and their own identity. We'll get reactions from our panelists on the other side of this. Stay with us. Welcome back. So we continue to, of course, unpack the Concourt ruling that essentially says that Parliament has 2 years to change some of our legislation to allow for men to take on their wives' surname. Again, if they so wish, the option is available. And I think the issue of choice really being important here as we have this discussion. But our panel's still with us. And we had, Peter from Foshville, Benedict, who's concerned about, wait, hold on, what does this mean for the children? And I wonder from a legislative point of view what we might see there. Peter says, if I'm Mtembu, my wife is Kumalo, what surname do my children hold? And are there, some issues there?
And that's a very interesting one, Naledi, because the court deliberately left that question open. There was that question before the court. But the court said, well, there are other provisions in the Births and Deaths Registration Act which relate to how you name your child, or the names that you give your child, or the surnames that are afforded to the child as part of the family unit. And those provisions were not actually implicated in this particular court process. So the Constitutional Court left that open and said it didn't have to deal with it. But what is of interest to Peter's point is that the court mentioned that when government was requested or directed to furnish representations to the court and explain what was the rationale behind Section 26 and the regulation, essentially what government articulated was that it was a way to trace family units. So if the surname belonged to the husband, the family units sort of could get traced around that. But what the court laid out is that, well, there's nothing that stops a family unit by being identified through a combination of the partner's surnames or one of their surnames, because ultimately you're achieving the same thing. The only difference is that the only person who couldn't decide what that family unit or the name that that family unit would take would be the female spouse in that particular instance. And because of that, then the differentiation was not justifiable, because you hadn't afforded the same right to the female spouse. And secondly, because it takes away the fundamental right for a female spouse to actually choose what she wants to achieve through the institution of marriage, it then violates not only the right to dignity, but linked to that, the right to equality. So, even within having said that there may be a loss of identity, it is more important, I think, in this particular instance, to accept that rationally it might not be the case given how the families are constituted. But secondly, it's more important that we give effect to the right to equality and the right to dignity, which are really part of the cornerstones of our constitution.
Yeah, interesting. Prof. Kolu, your view on the children. Babus Kumbuzo saying this is going to be a challenge for our identity. And of course, the issue of what this means culturally for children.
Well, thank you, Naledi. Firstly, I must point out that the concept of surnames is not all that old. People previously, before the colonial system came, were known by so and so of Naledi of your father, Naledi of this, and so on. And when you look at most of the surnames that we have today, they were actually original names of people. So it's not something that is too binding to the children. I heard that there are provisions for registration of the children in whatever surname is chosen by that family. But what is important is that because the married couple is now being given some freedom to choose which path to go, what we will start seeing happening, the cultural groups and activists will start by fighting it, and then they will then look at it, maybe if it becomes successful, after some decades and centuries, people will start moving on to the way of doing things according to their choices. There was also somebody who spoke about the genealogy of Jesus Christ.
Yes.
Well, in my other life, I'm a pastor, so I know a little bit of that subject. What happens when you look at the genealogy of Jesus Christ and how it is written, there are women there, except for that they were fighting for their rights against very powerful men. That is the first thing. The second thing is that the Jewish culture at that time did not count women and children at all. So when they say Christ fed 5,000 men or 5,000 people, they are referring to men. They're excluding the women and children who were there. And we've come a long way to sort of remove that discrimination, even now in the Jewish culture of today, which has modernized and is in line with the United Nations declarations on discrimination according to gender. So there is a background as to why the genealogy of Christ is full of males. There were women there, but the Jewish culture and the Church of the Sanhedrin did not recognize women and children.
Sure.
And that is the explanation. Where are we today as Africans in South Africa? We are on the decolonization project, where we were busy looking for roots and explaining things the way our forefathers explained them. It's going to be very important that, for example, when a woman marries to the Kulu family, she also comes here with her ancestor, at least one ancestor, which is her grandmother.
Right.
And my children actually can call on that grandmother when they have problems.
That's okay. I'm learning a lot today. I really, really am. And I hope that the views are the same from our viewers as well. In fact, let's take one last caller. Muzi is in Palm Ridge. Muzi, good evening. Thank you so much for calling.
Hi, Naledi.
Hi, Muzi. Thank you for calling. Talk to us.
Yes, ma'am. My comment is simple, ma'am. I think the guys that you invited in the studio, they are very learned and very educated. But I'm very disappointed with the position that they are taking now, because the way...
Yes, go ahead. I'm listening. Yes, I'm listening to you, Muzi. Go ahead.
Yes, I'm saying the men and women that we invited, they are very learned and educated. But I'm very disappointed with the position that they are taking now because they were not raised like that. The position that they are standing for now is because they are educated. They were not raised like that. They know exactly how things are done and they know how to follow the culture. But now, simply because they are educated, they are misleading even their children, their generation. So I'm saying I'm also disappointed with the position that was taken by the court today, because the court seems to be interfering with our culture and our family values, and I'm very disappointed with that. Thank you.
All right, Muzi, in Palm Ridge is saying these are academic points that are being raised, but this is not how we were raised in our own families. But let's take a look at a few WhatsApps as well from our viewers. Anonymous says, evening, Naledi. I hear your panelists saying it's a landmark victory for women. What I can say is, Safa singa abansundu aphela masiko oluntu. Okay, saying us black people are in trouble there and our culture being risked. And Siboleke says, good evening, Naledi. What needs to be understood is that there will be no compulsory assumption of the wife's surname. The law will allow for those who wish to use the wife's surname for both the spouses. So relax, comrades, your surnames are protected. Siboleke, thank you for that. And again, that needs to be reiterated. The choice is there if a couple wants to go that direction. Naledi, men are now becoming bomakoti. What a confusion. Anonymous. Again, it is a choice available to couples. Dr. Vilakazi Alberts, I'll let you have the last say. I mean, sure, we are quite the country, aren't we, with very rich views and massive debates that we continuously have. But obviously the issue of gender norms in South Africa continuing to be a big one. Where we take that conversation next as we continue to, as Prof. Olu says, decolonize, he says.
Naledi, it is a very, very interesting conversation. I think the speaker from Palm Ridge, I just want to say that what the law has actually done for us is to harmonize. It is not to destroy at all. It is to bring together the different cultures, the different experiences, and the different expressions of love. If you see in this case, in fact, one of the things that are being contested is about children being able to get the surname of both parents, or, in that way, comparatively what used to happen in the past. So it is about meaning, it is about symbolism, it is about really a sense of belonging. And what actually has happened, I think we need to point this out. Mr. Piri is saying that the Death and Birth Registration Act discriminated against women who were actually, in a way forced to take the surname of the husband. But in this case, in this contestation, we actually see that legislation, in fact, has also deprived men and people of other genders who actually would have preferred, and in this case in particular, to take the surname of their female identifying spouses. And for me, it's the point that shows that patriarchy really punishes all genders, right? It doesn't really just punish women, but it punishes men who say, I am not that kind of man that would want to always have my wife or my partner follow my way of doing, follow my ancestors when I am not able to follow their ancestors. All of us bring in all our experiences, our spiritualities, our joys and our happiness. I am the man that says, I am entering into this relationship and I'm loving you and I'm loving all of you. And I really want to identify myself in all of that, as you also do the same for me. So It's really a harmonization of beautiful loveness in society. And our constitution, just to close off, Naledi, I am aware of time. It's an affirmation of the Constitution of South Africa. Constitution of South Africa is the supreme law in the country. Section 9.3 in its entirety guarantees rights, including the rights of gender equity, between people of all genders. So this is what this ruling has done, and it's really landmark. We need to appreciate it and implement it in all our spheres of life.
Right. Well, thank you so much to our guests. Just the most insightful conversation. Benedict Piri, legal expert, Dr. Figile Shabangu Vilakazi Alberts, as well as Professor Musa Olu speaking to us this evening. You're still watching Newzroom PM, the late edition. We have your headlines after this.